I would like to start by thanking the organizers for inviting me. It is truly an honor to share the podium with so many distinguished speakers and experts in the field, and also huge responsibilities. So I'm hoping that I will live up to the expectations. Now, without further ado, I will start my presentation. Prosecution of war crimes committed in Bosnia and Herzegovina in 1990s began already during the war. Even after establishment of the ICTY, domestic judiciary continued to prosecute and try war crime cases in parallel with the tribunal under the concurrent jurisdiction allowed by the ICTY statute. However, by 2003, it had become evident that the ICTY will not be able to prosecute the majority of crimes that occurred in the territory of the former Yugoslavia. This realization prompted the adoption of the ICTY completion strategy proposed by the ICTY itself and formally endorsed by the UN Security Council. The strategy envisioned that the ICTY will focus on cases involving the highest ranking individuals, whereas cases of intermediate and lower level perpetrators will be transferred to national judiciaries. Sorry, but the task of handling a vast caseload inherited from the tribunal required strengthening of national capacities for prosecution of war crimes. As part of this process, the War Crimes Chamber was established within the Court of B&H. During the first 7 years, the War Crimes Chamber operated as a hybrid court composed of national and international judges. The number of international judges was gradually reduced over time, and since 2013, the chamber is comprised of national judges only. Even though, as can be seen on the slide, jurisdiction for prosecution of war crimes in Bosnia is shared among 21 domestic courts. Ever since its establishment, the Court of B&H has had primacy jurisdiction over war crimes and has been the leading judicial institution in Bosnia and Herzegovina when it comes to prosecution of these cases. To support this statement and also to give you some background for discussion that is to follow, I will briefly present the result the court has achieved over past 16 years. So from 2009, when it started trying war crime cases until the end of August this year, the Court of B&H processed 244 cases against 408 individuals. In most cases, prosecution was completed after the trial, and only 14% of the cases were resolved through plea bargaining. Charges brought against prosecuted individuals in completed war crime cases included genocide, crimes against humanity, and war crimes. As can be seen on the slide, in slightly more than half of the prosecuted cases, defendants were charged with war crimes, mostly against civilians. 41% of completed cases involve crimes against humanity charges, 3% combination of war crimes and crimes against humanity charges, whereas the crime of a genocide was charged in only 5% of the cases. At the end of August this year, the Court of B&H had 115 open cases against 325 defendants. However, as the chart illustrates, only 45% of these cases can be characterized as active, whereas in over half of the cases, proceedings have been put on hold because defendants are either beyond the reach of B&H judicial authorities or incapacitated to stand trial due to health problems. And these are, of course, only the cases that have reached the court. There are many more that are at the stage of investigation and that the court hasn't seen yet. To establish a legal basis for the prosecution of cases transferred from the ICTY and also to facilitate domestic prosecutions by enabling, among others, utilization of documentary evidence collected by the ICTY and adjudicated facts from the ICTY cases in war crimes trial before courts in Bosnia and Herzegovina. In 2004, B&H adopted the law of rather lengthy name, which I will refer to as a law on transfer of cases. My research examines how this law has been applied in practice in relation to the use of ICTY adjudicated facts in war crimes cases prosecuted at the Court of B&H. However, before I dive deeper into the topic, I would like to say a few words about the research and the research process. The first step in the research process was identification of completed cases, and the identified set of cases encompassed all 244 war crimes cases completed before the Court of Bosnia and Herzegovina from its establishment until August 31st, 2021. During second stage of the research process, I collected available trial and appeal judgments of identified cases, and the compiled set of documents for analysis encompassed 481 judgments comprising over 3,600 and 500 pages. The third stage entailed analyzing the collected documents. I used the court's judgments as a main source of information, and the research results I will be presenting today are based on data collected through analysis of these documents. I'm emphasizing this because the court's decision on motions for taking judicial notice of adjudicated facts are issued as separate written decisions during the trial, and judgment in most instances actually only summarize discussion from these original decisions. Given that the scope and detail of these summaries vary from case to case, the judgments did not always contain all the information relevant to the research. Although in most cases, discussion of adjudicated facts was sufficiently detailed and included key information relevant to the research, it wasn't always possible to fully complete the data set for all segments of the analysis. Judicial notice of adjudicated facts developed as a variation of judicial notice of facts of common knowledge. By taking notice of a fact of common knowledge, the court accepts it as proven without presentation of additional evidence. Eliminating the need to prove facts of common knowledge promotes expediency and efficiency of criminal proceedings. Judicial notice has long-standing roots in common law, but in civil law, not so much. Nevertheless, even though it's not universally accepted, this evidentiary rule appears to be very well established in international criminal procedure law. And the fact that it is incorporated into the statutes or rules of procedure and evidence of almost all international criminal tribunals and courts established since World War II attests to this fact. Moreover, rules of certain international criminal tribunals developed this mechanism even further by extending its application to adjudicated facts. Now, as part of the research, I have looked for examples of this mechanism being incorporated into national jurisdictions, and actually couldn't find any besides Bosnia and Herzegovina. So Bosnia might as well be the first and the only example of a country where this rule has been incorporated into national law. And even if it's not the first and the only one, it's certainly one of the very few. So in general, in this regard, I would like to emphasize that the practice of judicial notice is generally foreign to the VNH legal system, and it doesn't exist actually beyond the use of ICTY adjudicated facts in war crimes trials. As already mentioned, the legal basis for taking judicial notice of adjudicated facts is contained in the Article 4 of the Law on Transfer of Cases. The statutory provision authorizes the court to admit as proven those facts that are established by legally binding decisions in any other proceedings by the ICTY. The law on transfer is lex specialis in relation to the Criminal Procedure Code of Bosnia and Herzegovina, which prescribes the rules of criminal procedure, including the rules of evidence. Article 4 of the law on transfer is modeled on the Rule 94B of the ICTY Rules of Procedure and Evidence, which provides for the possibility of taking judicial notice of adjudicated facts. Although ICTY Rules of Procedure and Evidence and the BNH Law on Transfer of Cases use slightly different terminology, as you can see on the slide. The law on transfer speaks of accepting facts as proven, whereas ICTY Rules of Procedure and Evidence use the term judicial noticing. It is essentially the same rule of procedure. The law on transfer of cases doesn't explicitly define the objectives to be achieved by introducing the possibility of using ICTY factual findings in criminal proceedings before domestic courts. In this regard, it has been recognized in the Court of BNH judgments that this evidentiary rule promotes accomplishment of the following objectives: to improve advancing the efficiency and expediency of trial, protection of witnesses, and ensuring that defendants' right to trial without delay is respected. Once a court takes notice of a fact in this way, it creates a rebuttable presumption that can be challenged at trial. Because judicial noticing of facts already established in ICTY cases eliminates the need to prove them all over again, using adjudicated facts saves times and resources of all participants in the process by focusing the evidentiary proceedings to the more limited task of establishing what is essential to a particular case. Use of adjudicated facts further reduces the need to call witnesses to testify to the facts that have already been established in other proceedings, and thus it helps spare them the trauma of repeated testimony, and in the case of victim witnesses, of considerable emotional toil and psychological pressures. The court also acknowledged that the improvement of the economy and expediency of criminal proceedings achieved by accepting established facts also contributes to the promotion of the accused's right to trial within reasonable time, as guaranteed by both Criminal Procedure Code and the European Convention for the Protection of Human Rights and Fundamental Freedoms. However, although judicial noticing of adjudicated facts contributes also to the protection of the rights and interests of the accused, the court has repeatedly emphasized also that it is quite important to balance the interest of judicial economy and the right to a fair trial, which encompasses presumption of innocence as well as other procedural guarantees besides the right to trial without delay. Finally, even though this objective is expressly recognized only in a few judgments, using adjudicated facts certainly contributes to harmonizing judicial narratives about the war in B&H, at least in the part concerning general backgrounds of event. A few questions concerning application of this evidentiary rule emerge in practice. These are procedural effects of judicial notice of adjudicated facts, admissibility criteria a fact must meet to be eligible to be judicially noticed, and also procedural aspects of deciding on adjudicated facts. As the law doesn't provide answers to any of these questions, the court relied on the ICTY's jurisprudence developed in relation to Rule 94B as a guidance for practical application of this rule of procedure in cases prosecuted at the Court of B&H. So the basic question that arose when it comes to the effect of judicial notice is whether adjudicated facts admitted by the court can be contested or not. Following the jurisprudence of the tribunal, the court took the view that taking notice of adjudicated facts creates only a rebuttable presumption of its accuracy. When the court admits adjudicated fact, the fact is assumed to be proven and the party that proposed the admission of the fact is relieved of the burden of proof. However, the opposing party still retains the right to tender evidence to rebut the admitted fact. Thus, the admission of adjudicated facts doesn't mean that they are unconditionally accepted, nor does automatically bind the court to ground its verdict on them. On the contrary, in accordance with the principle of free evaluation of evidence, adjudicated facts are still subject to scrutiny and evaluation in the light of the totality of evidence presented at trial. In this regard, in several cases, the court expressly took the view that the finding of guilt cannot be based solely or decisively on adjudicated facts because they are based on evidence that was not presented directly at the main trial. Although this position is explicitly formulated in only 8 cases, the analysis of judgments reveals that in proving contextual elements of offenses, and adjudicated facts were used to that effect in most instances, adjudicated facts were regularly used in combination with other evidence, and the court often underlined in the judgment that adjudicated facts have been corroborated by other evidence as well. All this implicitly indicates that in practice, the court has taken the view that legal and factual findings cannot be based solely on adjudicated facts, but have to be supported by other evidence. The law on transfer doesn't define what qualities a fact must possess in order to be judicially noticed. The only formal condition that is prescribed is that the fact is determined by a final decision of the ICTY. In the absence of specific guidance in the legal provision, the court relied on criteria established through ICTY case law in deciding on the admission of adjudicated facts, primarily those defined in 2 decisions from prosecutor against Momčilo-Krajišnik case and the decision from Popović et al. Case. The court held that adherence to the criteria defined in this decision ensures that judicial noticing of adjudicated facts doesn't lead to a violation of the accused right to a fair trial. The analysis of available data showed that the court mostly often relied on the criteria from prosecutor against Momčilo-Krajišnik case, primarily those from the early from the earlier decision of 2003. In 61 cases, the criteria from prosecutor against Momčilo Krajišnik were applied independently. In 37 cases, in combination with Popović et al. Criteria. In 5 cases, the court applied only criteria from prosecutor against Popović et al. And in 7 cases, the court assessed the admissibility of facts on the basis of combination of criteria from the ICTY cases, further elaborated by the Court of B&H. The criterion prosecutor against Popović partially overlap with the criterion Krajišnik case and partially elaborate them further. The criteria are listed on this slide and the next one, and unfortunately, I don't think that we have enough time to go into detail as to how the court interpreted each of them and how it applied it in practice, but I hope I will be able to address that in the paper in more detail. In addition to evaluating the admissibility of facts in accordance with these criteria, the court also needs to ensure that acceptance of adjudicated facts would be in the interest of justice. So even if the court assesses that the fact meets all these criteria, it doesn't necessarily mean that the court has to admit it if it assesses that it wouldn't be in the interest of justice. The law on transfer also doesn't regulate in detail the procedural aspects of deciding on motions for taking judicial notice of adjudicated facts. And the only procedural rule contained in the legal provisions prescribes obligation of the court to allow the parties to the proceedings to respond to the motion of the moving party before reaching a decision. In the absence of concrete legal rules, the court resolved procedural issues that emerged in practice by applying provisions of the CPC, regulating similar matters while respecting the specifics and the purpose of these procedural mechanisms. One of the questions that arose is at what stage of the proceedings motions for taking judicial notice of adjudicated facts can and should be submitted. Although the law on transfer does not contain any restrictions in that direction, the analysis showed that in most cases motions were submitted during the trial, most often at the very beginning of the main trial. Given that the main purpose of judicial noticing of adjudicated facts is to achieve judicial economy, it is not surprising that the court took the view that admission of adjudicated facts should be proposed during an early stage of evidentiary procedure. Admission of adjudicated facts at the end of the trial would be pointless and could cause only unnecessary delays in the proceeding, which is actually the opposite effect of what is sought to be achieved. Guided precisely by the main objective of this procedural mechanism, in several cases, the court actually rejected the motions for admission of the adjudicated facts precisely because they were submitted too late. Another procedural question that the court had to resolve is whether the parties should be allowed to file an appeal against the decision deciding on the motion for taking judicial notice of adjudicated facts. In this regard, the question of the nature of this type of decision was also raised. The court took the view that decision on motions for taking judicial notice is a procedural decision and that judicial noticing of adjudicated facts is essentially a decision on the admissibility of evidence, and that the admitted adjudicated facts will be considered and evaluated after the main trial along with all other evidence that was presented during the proceeding. Accordingly, the court held that under the CPC, decisions of this kind, like any other procedural decisions that the court issues as part of managing the process of managing the trial, can be challenged only in an appeal against trial judgment. The analysis showed that parties moved the court to take judicial notice of ICTY adjudicated facts in 138 out of a total of 244 completed cases. In 131 cases, the Court of B&H granted the motions either in whole or in part and took judicial notice of ICTY adjudicated facts. Thus, ICTY adjudicated facts were used in slightly more than half of the cases completed before the Court of B&H. The number of admitted adjudicated facts in individual cases ranges from 1 to 410. In most cases, adjudicated facts concern the general context of war, general political, historical background, wartime organization and functioning of political administrative structures and military and police formation in certain geographical areas, and were used for proving crime-based and contextual elements of criminal offenses such as armed conflict, widespread and systematic attack, policy of persecution, or elements of criminal responsibility such as joint criminal enterprise and the like. The court noticed adjudicated facts from 29 different ICTY cases. Proposed facts originated usually from those ICTY cases which concern crimes committed in the same area, so which are linked by the case at question by a location of crime. For example, in the cases against defendants accused of genocide in Srebrenica, adjudicated facts usually came from ICTY cases involving Srebrenica genocide charges such as Krstić or Blagojević and Jokić. Similarly, in cases involving crimes committed in Prijedor region, noticed adjudicated facts came from cases against ICTY defendants charged with crimes committed in this region, like Brđanin, Tadić, Kočka, and others at all. In most cases, initiative for admission of adjudicated facts came from prosecution. Prosecution filed motions for taking judicial notice in a total of 133 cases. Defense proposed admission of adjudicated facts in 28 cases, and the court decided to notice adjudicated facts ex officio in only 2 cases. In approximately 2/3 of the cases, the opposing party challenged the motions for judicial notice of adjudicated facts, whereas in the remaining cases, motions were either not opposed or at least it wasn't mentioned, indicated in the judgments that they were challenged. The motions were challenged on various grounds. In majority of cases, the opponents argued that the proposed adjudicated facts do not meet admissibility criteria. However, most of the analyzed judgments did not discuss in detail how the court decided on these objections, so it is not possible to draw concrete conclusions as to how often these arguments were accepted and how often rejected. In significant number of cases, defense expressed a general opposition against this procedural rule, claiming that the admission of adjudicated facts shifts the burden of proof from prosecution to defense and violates defendants' rights to a fair trial and underlying procedural guarantees. The court rejected these arguments as unfounded in all cases in which they were raised. In several instances, defense additionally argued that judicially noticed adjudicated facts are considered established beyond a reasonable doubt and that they are therefore practically uncontestable. Needless to say, the court held that this argument is unfounded too, as it was based on the misinterpretation of the procedural effect of judicial noticing of adjudicated facts. Finally, in a number of cases, the defense argued that parties should be able to file an appeal against the court's decision on motions for taking judicial notice of adjudicated facts, and that the fact that such appeal is not allowed violates the right to defense. The court consistently rejected this argument too, with the explanation that parties are not denied the right to challenge the court's decision, but that as with other procedural decisions, they can exercise this right on the appeal against the trial judgment. However, the analysis has shown that parties chose to challenge decisions on judicial notice of adjudicated facts on appeal in less than 25% of the cases. According to available information, in majority of analyzed cases, parties' motions for taking judicial notice of adjudicated facts were only partially granted. Only 10% of the motions submitted by prosecution and 40% defense motions were granted in whole. As the charts illustrate, defense had a better success rate than the prosecution when it comes to fully granted motions, but at the same time, they also had significantly higher rate of denied motions, 27% compared to 5% of prosecution motions. The number of adjudicated facts that the court refused to admit in individual cases ranges from 1 to over 300 adjudicated facts per case. There are a few possible explanations as to why in most cases, at least some of the proposed adjudicated facts were rejected. First, it could indicate that even though the court was consistent in embracing and relying on the same admissibility criteria, different judicial panels simply in practice differently construed and applied these criteria against the proposed adjudicated facts, which as a consequence produced inconsistent jurisprudence and uncertainty as to how criteria will be applied in a particular case. Other possible explanations would be that parties were either not sufficiently familiar with the court's jurisprudence in this regard, or that they simply chose to try their luck and propose all adjudicated facts that favor their case without conducting a meticulous assessment of whether these facts will fully fulfill admissibility criteria. The analysis of the available information showed that the court in most instances refused to take notice of the proposed adjudicated facts because they contain legal conclusions or characterizations of a legal nature. In almost as many cases, the court assessed proposed facts inadmissible because it considered them irrelevant for a specific case or because they were not sufficiently clear, distinct, and identifiable. In a number of cases, the court found that the proposed facts do not fulfill other requirements, such as that fact be established by final decision, that it doesn't attest to the criminal responsibility of the accused, that it is not based on the agreement between the parties to the previous proceedings, and that it is not the subject of reasonable dispute between the parties in the present case. Finally, in a number of cases, the court took the view that adjudicated facts should not be accumulated and refused to notice those facts which aim to attest to the same circumstances as other facts proposed by the moving party or in relation to which the moving party already presented substantial evidence. To conclude, the Court of B&H has achieved important results in the prosecution of war crimes. Over the past 16 years, it has tried a significant body of cases and developed robust standards for effective war crimes prosecution and utilization of ICTY findings, jurisprudence, and practices without doubt contributed to these accomplishments. The analysis of war crime cases processed before the Court of B&H showed that the ICTY adjudicated facts have been used to a considerable extent, which indicates that this evidentiary rule has been recognized as an effective tool for accomplishing expediency of criminal proceedings. The actual effect of the application of this mechanism cannot be precisely measured, in the sense that it is possible to determine to what extent judicial noticing of adjudicated facts really contributed to shortening of the proceedings by reducing evidence to be presented or witnesses to be heard. However, the fact that in complex cases, such as those involving genocide and crimes against humanity charges or complex mode of criminal responsibilities, such as command responsibility or participation in joint criminal enterprise, where proving elements of the crime and the responsibility of the accused requires establishing crime base and the broader context of events, the number of admitted facts reaches several tens, often even several hundred facts per case, speaks volumes about how significant judicial noticing of adjudicated facts has been for promoting judicial economy in war crimes cases. However, although there is no doubt that the use of adjudicated facts significantly contributed to the efficiency of war crimes trials in B&H, the mechanism of judicial notice was not utilized to its full potential. First, by opting for a more restrictive interpretation of certain criteria for assessing the admissibility of adjudicated facts, the court limited the range of factual findings that can be admitted and thus the scope of application of this mechanism. Secondly, the court's position that admitted adjudicated facts need to be corroborated by other evidence diminished the effectiveness of this tool. Finally, the effects of incorporation of this evidentiary rule in the legal system of B&H would have been certainly greater if, as it was originally conceived, the use of adjudicated facts came to life also in the practice of other courts in B&H dealing with war crimes. Unfortunately, except in a few cases, this mechanism hasn't found its application in the prosecution of war crimes before B&H courts, other than the Court of B&H. Even though the mechanism of judicial notice may not have been utilized to the fullest extent possible, the Court of B&H case law is a good example how international jurisprudence and experiences can be utilized to advance legal and procedural practices in domestic war crimes prosecutions. Through incorporation of the mechanism of judicial notice of adjudicated facts in national law and its utilization in practice, not just ICTY factual findings, but also the tribunal's rules of procedure and evidence and its jurisprudence found practical application in domestic war crimes trials in Bosnia and Herzegovina. For other jurisdictions that in the future may face the challenge of prosecuting a large number of war crime cases, the B&H experience provides a good basis for considering whether and how to incorporate this rule of evidence in their legal systems. Just like the Court of B&H case law and lessons learned offer guidance to other national courts for overcoming the challenges of practical application of this mechanism. Thank you very much. I will be happy to answer any questions that you may have.